Good morning. We don't get to say that often in Commerce and Labor. So good morning, Assembly Committee on Commerce and Labor. Madam Secretary, please call the roll.
Assemblywoman Carlton.
Here.
Assemblywoman Considine. Assemblywoman Dickman. Assemblywoman Duran. Assemblyman Flores. Assemblyman Frierson. Assemblywoman Hardy. Assemblywoman Kasama. Assemblywoman Martinez. Assemblywoman Marzola. Assemblyman O'Neill. Assemblywoman Tolles. Chair Howdagi.
Here. Thank you so much, Madam Secretary. Please mark other members present as they arrive. I know they are making their way out of their morning committee. Okay, welcome everyone who is here in person and to everyone listening in over the internet. Before we start, I would like to make some quick housekeeping announcements. Please remember all exhibits, written testimony, and amendments must be submitted by noon on the business day prior to the committee meeting. Persons who wish to provide testimony or attend the meeting must pre-register online at the legislature's website. The public is strongly encouraged to submit written testimony in advance of the meeting by emailing the Assembly Committee on Commerce and Labor. Members and people who are present, please remember to silence your electronics. Members who are watching and here present, please note that committee members are using electronics to view exhibits and to view bills. It is not a sign of disrespect or inattention. Presenters on Zoom, please remember to be muted at all times. Unmute yourself to speak and then promptly mute yourself when you are done. And if you could please keep your cameras on, that is the only way we can see you on Zoom. Thank you, everyone, and let's begin with our agenda. We have a short agenda today, 2 items that we will be taking out of order. I see our first presenter is already here, and so welcome, Senator. I will now open the hearing on Senate Bill 248, and we have Senator Don Darrow Loop here to present. Senator, did you have co-presenters with you? Oh, there they are. Okay. Thank you, Senator. When you're ready, the floor is yours.
Thank you so much, Madam Chair, and it is always a pleasure to come back and visit the Assembly, and I see some really wonderful, familiar faces that I haven't seen in the building yet. Thank you, Chair Howdagi. For the record, I am Marilyn Don Darrow Loop, representing Senate District 8 in Clark County, and I'm pleased to present Senate Bill 248, which seeks to assist consumers during the collection of medical debt. I am pleased to be joined by Sophia Romero on Zoom, Consumer Protection Attorney at the Legal Aid Center of Southern Nevada, and Bailey Bordelin, Statewide Advocacy Outreach and Policy Director of the Nevada Coalition of Legal Service Providers, who will provide additional context and details for this bill. During the unprecedented COVID-19 pandemic, most states issued lockdown orders that closed many workplaces. The ensuing job losses have left millions of workers without employer-sponsored health coverage. Studies estimate that as many as 7.7 million workers lost their jobs with employer-sponsored insurance because of the pandemic-induced recession. The employer-sponsored insurance of these workers covered 6.9 million dependents for a total of 14.6 million affected individuals. However, even pre-pandemic, almost 42% of Nevada households were not covered by an employer-sponsored insurance plan. According to the Urban Institute, 21% of Nevada's population have some form of medical debt in collections. For communities of color, it is 26%. For these reasons and others, it is necessary that we implement protections for consumers with medical debt in Nevada. Soon, time will tell how many job losses are ultimately permanent, resulting in loss of employer-sponsored insurance for workers and their dependents. Chair Howdagi, before we discuss the provisions of the bill, I would like to turn the presentation over to Ms. Romero. And I believe Ms. Bordelin is in the audience with us, but Ms. Romero is going to do this part, and I would like her to discuss with you the need for Senate Bill 248.
Thank you, Senator. Ms. Romero, welcome to the Assembly Committee on Commerce and Labor. When you're ready. Oh, Ms. Romero, I believe you are muted. Okay, we still can't hear you. Ms. Romero, I believe you're still muted.
Howdy, can you hear us?
Yes, there you are.
think she-
Mr. Lewis, can you help Ms. Romero?
Yeah, I think there was something on the back end that was not working, so let's give it a try again, Ms. Romero.
Thank you,
Good
Mr.
morning, Chair. Are you able to hear me now?
Yes, thank you, Mr. Lewis, and Ms. Romero, we can hear you loud and clear.
Thank you. Good morning, Chair, Vice Chair, and members of the committee. For the record, and as Senator Dendera Loop stated, my name is Sophia Romero, and I'm a staff attorney in the Consumer Rights Project at Legal Aid Center of Southern Nevada. Thank you for the opportunity to help present here today. Before I walk through the bill, I would like to thank Senator Dendera Loop for bringing this very important piece of legislation. This bill will be a much needed addition to Nevada law and not only will help people who are currently facing medical debt collection, but will help countless others going forward as we see the results of the pandemic unfold. In my role helping the low-income population of Clark County, debt collection is an everyday occurrence. There are times when the client has insurance, but is still being sued by a debt collector on the debt due to billing errors for which the client's not responsible. Other times, the client is being sued by a debt collector well past the statute of limitations for services that occurred years ago. Finally, and perhaps most egregiously, is when the client has Medicaid and is still being sued in a practice known as balance billing, which is strictly prohibited. But these clients are the lucky ones. These are the clients that I get to help because the debt collector is clearly doing something wrong that is prohibited by statute. These are the people that I get to tell, don't worry, I can help you. But there are so many others. So many who don't know that legal aid exists, who maybe don't have a defense, but nonetheless just can't afford to pay. This is where SB 248 comes in. It helps regulate the behavior and limits the fees charged by debt collectors so that people with no other defense can at least have a chance to pay back their debt without being forced into bankruptcy. One practice that SB 248 seeks to eliminate is debt collectors taking what is known as a confession of judgment against someone with an outstanding medical debt. Oftentimes, consumers will go to the debt collection office to set up a payment plan. The collection agency will say that they have to sign the document which contains the payment schedule. People sign this thinking they are entering into a payment arrangement and having no idea what they actually just signed. Then if they are even 1 day late, and in some instances when they have never been late, but a clerical error has occurred, the confession of judgment is filed with the court. This confession of judgment has the same effect as if a court had found in favor of the debt collector and means that the debt collector can now begin garnishing wages and taking other collection actions against that debtor, with the judge having never even seen the case. Additionally, people who have minor small dollar amount debt end up owing thousands due to collection fees in these matters. Default judgments are entered in matters where no defense is raised and no litigation is required. Despite the fact that no litigation is required, we have seen default judgments on an underlying debt of $6,000 turn into nearly $13,000 in debt. A $688 debt became a $2,600 debt, and a $431 debt became a $1,400 debt, all based on collection fees and costs. Even when the consumer enters into a confession of judgment, once that judgment is entered, fees are charged, turning, for example, a $2,800 debt into a $7,000 debt. Now, these are cases where not even a complaint was drafted. Literally, just the piece of paper that they signed in the debt collector's office was filed with the court, and that debt turned from $2,800 into $7,000. We want people to pay back their medical debt, but we want to give them a fighting chance to do so. When the amount of debt is inflated due to collection and attorney's fees, we take away people's ability to work towards paying their debt and are instead pushing them towards bankruptcy, where oftentimes there's no chance of the debt ever being paid. These abusive debt collection practices are the practices that SB 248 intends to regulate. This bill only applies to debt collectors and does not change the practices or rights of hospitals and other medical providers. It does not conflict or change anything in NRS Chapter 449, 449A, or 621, as those statutes only apply to providers and not debt collectors. Furthermore, the protections that SB 248 would put in place are in addition to the Federal Fair Debt Collection Practices Act, which focuses on behavior and transparency and does not regulate the amounts of the debt that debt collectors can charge. With that, I will walk through the bill. SB 248 is a fairly simple and straightforward bill. Sections 1 through 6 contain the definitions. Section 7 talks about notice. This section requires a collection agency to give notice at least 60 days before to the debtor at least 60 days before taking any action to collect the medical debt. This 60-day period allows time for the patient to go back to the provider or insurance to investigate and determine if they actually owe this amount of money. The written notice provided by a debt collector to a person who owes a medical debt must include the name of the healthcare provider, medical facility, or provider of emergency services that provided the goods or services for which the medical debt is owed, and the date when the goods or services were provided. Again, this is all information so that the debtors can go back and make sure that this debt is actually valid and that they actually do owe it. The proposed amendment, which has, I believe, been uploaded to Nellis, has removed paragraphs C and D of section 7 and has removed subsection 2 of that section, as subsection 2 is just a definition for a term that was used in paragraph D, I believe, either C or D. And we remove those paragraphs as it might cause confusion to some consumers. Section 8 prohibits a collection agency or its manager, agents, or employees from engaging in certain practices relating to the collection of medical debt, including taking any confession of judgment or any power of attorney running to the collection agency or to a third party to confess judgment or to appear for the debtor in a judicial proceeding. Commencing a civil action to collect the medical debt if the amount of the medical debt, excluding attorney's fees, collection costs, interest, late fees, and any other fees or costs, is less than $10,000, which is the maximum jurisdiction amount for the justice of the peace for small claims court. Here, we did actually introduce another sentence into the amendment just to clarify that nothing in this bill prevents a debt collector that is suing for less than $10,000 from filing a small claims action. So we are not taking away any right to file in small claims here. We are just making sure that if the matter qualifies for small claims, it's filed in small claims. And it also prevents the debt collector from charging or collecting a fee of more than 5% of the amount of the medical debt, excluding attorney's fees, collection costs, interest, late fees, and any other fees or costs as a collection fee or as an attorney fee for the collection of the medical debt. With that, thank you for your time, and I am available for any questions that the committee might have.
Thank you, Ms. Romero. Senator, I believe, was...
Thank you, Chair Hudigy. That concludes my part of the presentation and also Ms. Romero's. They are available for questions, so I'm going to step back and let Ms. Bordelin take this seat. And thank you very much.
Welcome, Ms. Bordelin, and you're here for Q&A, correct? For questions only?
Correct, thank you.
Members, any questions?
Chair, if I could very quickly, I do want to just start by emphasizing that the amendment that you have in Nellis on Section 8, Ms. Romero did cover this, but there was just some confusion. The intent of that section and the way that it is drafted legally and technically does require that an amount of debt less than $10,000 go to the appropriate jurisdiction, which is small claims court, because that people's court is set up so that excessive fines and fees and attorney's costs and those things don't get added to cases. The confusion that some of the stakeholders had, which is very valid if you don't live and breathe in this world, is that a civil action is separate and distinct from a small claims action. So there were people who read that to mean that we were saying you couldn't collect any debt less than $10,000, but that was just a small legal technicality, that a civil action and a small claims action are two different types of actions, so that access to a small claims action was never restricted.
Okay, thank you, Ms. Bordelin, and I believe we do have a question from Assemblymember Tolles.
Thank you, Madam Chair. I just have a couple of clarifying questions, wrapping my head around the amendment. So essentially what's left is we've got a 60 days notice. And then in Section 8, we have that the collection agency shall not take any confession of judgment, commence a civil action. However, they can still commence take an action to the small claims court for less than $10,000. So really what we have left is, again, 60-day notification, and that they shall not charge or collect a fee of more than 5%. That's really the meat that's left as I read it. And how much do we know if we had any kind of cap on the amount that they could collect before that? Is this a brand new cap by putting in that 5%? And do we know what they typically collect in fees? Is this a drastic, do they collect 20% now and we're limiting it to 5%? Is it all over the place, or is it pretty close to standard?
Bailey Bordelin for the record. I'll ask Sophia Romero to speak to that. I think we believe that these are best practices, and we are seeing these put in place in other legislatures as well, particularly because of the pandemic. But we do also have a very long list of egregious cases that we see, right, where would be a drastic change from some of the more predatory practices that we do see. So I'll have Mr. Romero speak to that.
Thank you. Sophia Romero for the record, through the chair to Assemblywoman Tools. So there is no current cap in place on the amount of collection fees or attorney's fees that can be charged in these type of cases. Again, with some of the examples, we've seen a $200 debt turn into a $1,400 debt. And that is, I haven't done the math specifically, but that's well over a few 100% of the amount of the debt. Contracts, debt collectors can typically anywhere charge from 50% to 100% of the amount of the debt. And what we're really trying to do is really bring that down so that people actually have a chance to be able to pay these dollar amounts back. If your debt is, $200, then and now all of a sudden you owe $1,400, it's much more likely that you'd be able to pay the $200 and actually get out of that debt than you would when it's $1,400 and now you are burdened by those extra fees. And that's all they are, is fees. They're not actual principal.
Thank you. Follow-up, Madam Chair? Thank you. And thank you, Ms. Bordelin, for mentioning other states. If you do have any data on that, that would be very helpful to see just where we stand versus other states in regards to cap, no cap, and what the amount is, if that's possible. And a second question, if I may, just clarifying. So we've taken out of Section 7 the references to the third party, but we still kept in Section 8, subsection 1, that a collection agency shall not take any confession of judgment or any power of attorney running to the collection agency or to any third party to confess judgment. Will that also be taken out, or is that still left in without third party being defined?
Bailey Bordelin for the record. That is a good catch, and I'm sure that's why we have drafting look at my version of the amendment, so we'll leave in a definition of third party.
Sophia Romero, if I may. So this actually is, this is not a third party. This is a third person. So what this is saying is that they're saying that you cannot have, as the debt collection agency, you cannot have a debtor sign over a sign a power of attorney giving the debt collector or a third person. So somebody, let's, for example, say the debt collector or the debt collector's attorney. You can't have them sign a power of attorney that then the debtor cannot sign a power of attorney that would give power of attorney to the debt collector or a third person, aka their attorney. That's the difference there.
Sorry, Madam Chair, one last clarification. If they could put that in layman's terms, what exactly does that, who does this impact? I think that might help for understanding.
Again, Sophia Romero for the record, Madam Chair, through you to the Assemblywoman. This only affects the, essentially bars a debt collection agency from requiring a person to sign a power of attorney and giving the debt collection agency or, for example, their attorney, a third person, right to a power of attorney over the debtor, if that is more helpful, hopefully.
Thank you, Ms. Romero. I'm going to go to Vice Chair Carlton next.
Thank you very much, Madam Chair. So in looking at this, gosh, I wish I would have had that 60 days. A number of years ago, my daughter was ill and we had to take care of a lot of her medical bills and ran up against a number of barriers. They ended up going to collection because the deductible had not been paid in the sequential order that it needed to be paid in. So it was a bureaucratic mess that took us a while to straighten out, but because we were straightening it out, she ended up in the collection position. So, and one of the things I found out in that is that the providers, hospital, ambulance company, whoever it is, will actually sell that debt to someone else for possibly pennies on the dollar. But then that group wants to collect the full amount, and they're still allowed to add on the cost of doing business with interest, late fees, collection costs, attorney's fees, and any other fee they can kind of think of to actually put on there. So, Ms. Romero, I'm just wondering, was that a one-off, or is that the typical way that they do business? And I've also been told that some hospitals will actually have their own collection companies so that they can turn the debt over to the collection company, take the write-off, but still get the dollars from the patient on the other side. But I've not actually seen an instance of that, but I've been told that that does exist in some places, and I'm not sure if it exists in Nevada. So have you seen any cases along that line? And do you have any information on how much this debt actually gets sold for in the long run?
Sophia Romero, for the record, through you, Madam Chair, to Assemblywoman Carlton. You are 100% absolutely correct. This debt is sold for pennies on the dollar. And each time it's sold, there's a phenomenon called zombie debt. And so the original provider of services will sell it to debt collector A, who will sell it to debt collector B, who will sell it to debt collector C, and so on and so forth. And each time that it's sold, the purchase price is lower and lower. So perhaps the first, I don't have hard data for you on this. It's probably a pretty well-guarded secret. And maybe some of the other attorneys, like at the National Consumer Law Center, might have more information that I could possibly try to research for you and find that out. This was a concern brought up on the Senate side as well. Senator Neal also brought up the fact that these debts are sold for pennies on the dollar, and then the debtor is still on the hook for the entire amount of the debt. And so again, as they're sold on continuously, the amount that they're purchased for goes down and down, but the amount of the debt gets higher because you have now either, first of all, there was the principal balance, which is you have to pay that in full. But now there are, multiple debt collection fees, late fees, any type of interest, any of those type of things. And so the debt keeps going up when the amount that the debt buyers or debt collectors are purchasing it for is actually going down. So the margin, if they are actually able to collect in the end, the margin of profit is much greater than it would have been. As far as your second example with the in-house collection, yes, once these go to debt collectors and debt buyers, they are written off the books and they do get a tax credit for that. And I have heard of certain providers or hospitals essentially having their own kind of captive debt collector. And I believe that those two examples that you gave were spot on, and that does occur.
And a brief follow-up, Madam Chair. So what is the statute of limitations on medical debt? How long do you have to survive this harassment before it goes away?
Sophia Romero, for the record, through you, Madam Chair, to Assemblywoman Carlton. The statute of limitations on medical debt in Nevada is 4 years. And however, you have to know that, right? So a debt collector, and in one of my in my testimony, one of the examples of when I can help a person is when they're being sued outside the statute of limitations. The problem is if you don't know that the medical debt statute of limitations is 4 years, because in Nevada, we think of all contracts as being a 6-year statute of limitations. That's our big statute of limitations. Everybody knows contracts are 6 years. And so if you don't know that medical debt is a 4-year statute of limitation, then and you get a debt collection letter, If you go ahead and make a payment on that, you have just restarted your statute of limitations. So if you all of a sudden, let's say you moved and didn't get the initial letter, and all of a sudden, finally, 4.5 years later, they find you, and you call them up and you say, oh, I didn't know I owe this debt. Can I make a payment? Because they will harass you. Pay me $100. I can't afford that. Pay me $50. I can't afford that. And so, but their goal is to try to get you to pay anything, because once you pay anything, that statute of limitations starts again. So then, you're looking at an additional 4 years.
Thank you very much, Madam Chair.
Thank you, Vice Chair. I'm going to go to Assemblymember Dickman next.
Thank you so much, Chair. I was just wondering, is it possible that there's a conflict here with the 60 days? Because in NRS 449.757, it says hospitals can begin collecting in 30 days.
Sophia Romero, for the record, through you, Madam Chair, to the Assemblywoman. That statute no longer exists and hasn't existed for some time. I noticed that myself, that it was included in that letter, but it's not in the current NRS that I could find. A couple of attorneys from our office were looking for that. That doesn't exist. What I believe they were trying to get to, and what I believe there was some renumbering done with the statutes going all the way back to 2007, and I think maybe again in 2011. But I think what that is getting to is hospitals are not allowed to charge interest on a debt until 30 days after they have billed the insurance, because they want the insurance. The point of the statute was to give the insurance 30 days to pay. And if somebody is waiting for their insurance to make a payment, they shouldn't be being charged interest. This has absolutely zero effect on that. This is once the debt has left the hospital, right? So the hospital can start charging interest after 30 days. Once the debt has left the hospital and now has been sold to a debt collector or a debt buyer, when that debt buyer reaches out to that debtor, they have to give them now 60 days notice before they take any type of collection action. So that's saying, hey, we own your debt now. You have 60 days from the date of this letter to figure out what's going on here, so that you can take either the appropriate steps to make a payment, or to figure out a payment plan, or to dispute this debt, saying that it's not valid, that you don't actually owe it. So that is a completely separate set of statutes. This has no bearing on Chapter 449 at all. This only applies to debt collectors, and this only applies after the hospital has either written off the debt or sold the debt. Well, actually, same thing. But it's after the hospital has already gotten rid of the debt, and it's now in the hands of a debt collector that this would apply. It has nothing to do with the 30-day waiting period for hospitals to begin charging interest on a bill.
Thank you. And I want to jump in really quick, because Ms. Romero, when you say debt collectors, you specifically mean like collection agencies, correct? Thank you.
Yes, Madam Chair.
Assemblymember Dickman, did you have a follow-up? It's not exactly follow-up. It's another question. Okay. Go ahead.
Thank you, Chair. I was just curious, so if small claims is limited to what, 5,000? And, small claims is 10? Okay. So if you owed more than that, you would have to go to?
Sophia Romero, for the record, through you, Madam Chair, to the Assemblywoman. If you owe more than $10,000, then the case can be filed in justice court of the appropriate jurisdiction. So, for instance, North Las Vegas Justice Court, Las Vegas Justice Court, Reno Justice Court, any type of justice court, they would have jurisdiction.
Okay, thank you. Thanks, Chair.
Assemblymember Marzola?
Thank you, Madam Chair. Thank you for the bill. I think it's a great bill. I do have a quick question on Section 7. I see that Part C was deleted, whether a third party has been billed for those goods or services and the current status of the bill. And I'm wondering what the thought process was there. How come we didn't keep that in? Because I think it's really important.
Sophia Romero, for the record, through you, Madam Chair, to the Assemblywoman. The reason that was taken out was it was a concern raised that by the stakeholders that consumers might be confused, because by the time a bill has gotten to a debt collector, usually the time frame for billing insurance or for resubmitting a claim may have closed. And I believe I tried to get clarification from the stakeholder, and I didn't get an exact answer. I believe the same would be true with subsection D, where if for hospitals that have, like nonprofit hospitals, for instance, that have financial assistance programs, I believe that once it's been turned over to a debt collector, that window for any assistance or any additional insurance billing might have been closed. I, again, did not get a specific answer on that, but these changes were made in direct response to concerns raised by stakeholders.
Bailey Bordelin, if I could add to that, we worked with the hospitals on that piece, and so there's multiple hospital associations, but Mr. Wadham's worked with us on this, and I think some of the concern was that this does not change when the hospital is giving you that information on the front end. So of course that's still very important in that initial collection process. It's just when we're in Chapter 649, so once it's been bought and sold, and what the debt collector has to provide currently is not a whole lot of information. So we have debt collectors who will not be upfront about where they got this debt or what this debt is or where it came from. And so just providing people with more notice that this is from this hospital when this happened, so they at least know why you're coming after them, will bring some of that clarity. But the hospitals were concerned, and I believe he will be on to speak, so I'll let him speak to that there may be some billing confusions if it seemed like it was still open at that point after they had negotiated it away.
Okay. So if you have follow up, thank you, Chair. If you have an instance of insurance was billed, you have co-pay left over, right? Even if it's a few $100s that you're not aware of, it gets sent to collections. They're trying to collect 6 months, a year later. The patient no longer has that insurance, doesn't have that information. Wouldn't it be better to be provided by the collection agency to that consumer patient? Am I making sense of my question?
Yeah, Bailey Bordelin for the record. I do believe that will all happen when the hospital is negotiating with the patient, because the hospital will make efforts to collect and will try to set up payment plans. And so there's still that transparency and that process happening there. And it's only at a later date when they're selling it to the debt collector. So the hospital is removed from the situation and no longer a party to the debt, essentially.
Okay, thank you.
Next, I'll go to Assemblymember Hardy.
Thank you, Chair, and thank you for bringing this bill forward and having this discussion. So I just want to make sure, get some clarification, especially with the amendment on Section 8. I think there was a lot of discussion about the $10,000 amount. So if a collection agency would not be able to collect on something under 10,000, so that would mean that a provider, a facility, ambulance service, what have you, has something under 10,000, let's say it's even under 1,000, they would have the option, either themselves or hiring an attorney, to go to small claims to collect for that. Do I understand that correctly?
Bailey Bordelin for the record. So small claims court is a bit more informal, but the jurisdictional amount currently for anyone to be able to access small claims court is $10,000. So it could be $5, it could be $9,000. Anything under $10,000, people can go use small claims court. Some of the protections are built into that is that attorney's fees can't be tacked onto it. So while anyone could use it, there are some consumer protections around it so that if you are collecting a $100 dispute, it doesn't turn into something much less affordable based on the fact that you went to this court proceeding.
Okay, and that was my other, going through my thought process is, since you can't add attorney's fees, a lot of times attorneys don't want to do small claims. So then at that point, the provider or whoever it is, they would have to pursue this themselves then for anything under 10,000, correct?
Bailey Bordelin for the record. Thank you for the question. It doesn't necessarily have to be you. So we often see in small claims court property managers appearing on behalf of landlords, right? So you can appear on behalf of someone else. You can have someone in-house in your company, in your agency. You could hire someone to go, but attorney's fees couldn't be charged for that person's services inside of the debt claim. Couldn't be ordered by the court, I guess is a better way to say it.
Members, any other questions? Assembly Member O'Neill.
Thank you, Madam Chair. Ms. Bordelin, I appreciate some of the explanations. Sometimes I understand it, then somebody else asks a question, so I just needed some clarification. On Section 7, why the 60 days still? I mean, I know when I owe money to somebody, so you're going to send me a letter, and which is the second part of the question, is just one letter, where's the verification that I received the letter? Can that be an argument proposed by the debtor to protect themselves that I never got it, I never saw it, or whatever, or I moved type of thing? So it's a two-part there. Why 60 days? And should maybe the letter be more of a certified letter with return, some proof of service?
Thank you for the question, Bailey Bordelin for the record. So I do believe that the collectors keep thorough records of all of the communications that they are having with people, so they would have proof of that letter as part of the business practice. I think why 60 days, Assemblywoman Carlton gave a good example of if you're getting notice of this and you don't know where it's coming from, perhaps you have moved and someone was trying to collect at a previous address, or your phone number has changed and now you're being contacted, it allows you the breathing space to figure out what happened and to try to go back and make a plan and connect the dots, because this has been sold to a new agency. That agency doesn't answer your questions about what happened, what went wrong here, was my insurance billed, right? And so it's giving you the space to be able to have a path forward, but I think Mr. Romero could speak to some examples of where we would see that be helpful as well.
Sophia Romero for the record, through you, Madam Chair, to the Assemblyman. I actually really like the idea of having debt collectors send the notice via certified mail. We did not consider that option because we did not want to have them incur any additional costs because of this mailing on the bill. But actually, that is a very good point. It probably should be certified, because then they have proof that the debtor received it. And because, on the flip coin of it, they can always say they sent it and print off a piece of paper and keep that in the file and never actually put it in the mail. So yes, some type of proof would be nice. But then to kind of give your example again, with Assemblywoman Carlton's example, for instance, let's say, this has even happened to me personally. I with my first child, I went to the hospital, had the baby, came home and I had paid my copays and everything up front, because they know how much your 20% is or whatever. So I paid all my hospital bills up front. And then 2 years later, I think my son was 2 or 3, I got a collection call saying that I owed the hospital money, and I didn't understand why. And apparently they had been trying to bill me under the incorrect last name. They had my maiden name and not my married name. And we had moved a couple times, and all of a sudden I was in collections. And because I am extremely OCD about my credit report, I immediately, called up and paid it. But I had to call and check with the hospital and say what happened. I paid up front. Why did this all go through? So it happens. It happens to people, and it can happen to any of us. And that is just kind of one example of why that 60-day window is really nice, because then you can have time to contact your insurance and did I really owe this money, or contact the hospital and say, hey, what happened? I paid you up front. Why did I end up getting charged? Why did I end up going to collections? Those type of things.
May I ask a follow-up, please? I'd like to respond. You help me out. So the discussion I would have during that 60 days is back with my insurance or the hospital itself. And if I clarified it, as you said, Ms. Romero, they had billed you incorrectly under the, I forget if you said your maiden name or your married name, which you were going by. Is the fees by the debt collector then forgiven and it's, as we used to say, all good? What's the process once you've identified that, hey, it's not my fault? That's what I'm curious about.
Sophia Romero, for the record, through you, Madam Chair, to the Assemblyman. That's I have to give a lawyer answer here, and really that is, it depends. It depends on the collection agency. It depends on their internal practices. It depends on who you get on the phone and if they want to work with you or they don't want to work with you. Doing what I do for a living as a consumer rights attorney, I did not have to pay any fees. I cannot say that that's true for everyone. I wish that were true for everyone, but we wouldn't have to bring legislation like this and be here today if it were true for everyone. So in my personal example, no, I did not have to pay any fees. Do other people have to pay fees? It's extremely likely.
Thank you. Thank you for the time, Chair.
You're welcome, Assembly Member. Okay, at this time, I am going to move into the testimony portion of the hearing. I don't see anyone in Carson City wishing to testify in support. Broadcasting, do we have anyone on Zoom to testify in support?
Is there anyone in this Zoom call who is here to give testimony in support? Chair, there's no one else in the Zoom call.
Thank you. Broadcasting, could we go to the telephone line for those wishing to testify in support?
Thank you, Chair. To testify in support of Senate Bill 248, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 199, please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Good morning, Chair, and well, I guess it's afternoon now. So good afternoon, Chair and members of the committee. My name is Tess Opferman, speaking on behalf of the Nevada Women's Lobby. That's spelled OPSERMAN. We want to thank the Senator and legal aid for bringing forward such an important bill. Medical expenses are incredibly high in the United States, even with insurance coverage. Roughly 20% of Nevadans have some form of medical debt. That is 1 in 5 people. Low-income individuals may struggle to pay their medical expenses, so they don't pay them, and then these bills become increasingly more expensive, creating a dangerous downward cycle. Though medical debt needs to be paid, there also needs to be some protections to ensure we are not costing low-income families extraordinarily high amounts on top of their original medical expenses. This is a critical consumer protection bill. We urge your support, and thank you for your time today.
Thank you for your testimony. Broadcasting, next caller, please.
If you recently joined the call and would like to testify in support of Senate Bill 248, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 411, please slowly state and spell your name for the record. You'll have 2 minutes and may begin. Caller with the last 3 digits of 411, please press star 6 to unmute.
Thank you. This is Michael Kind, Michael, last name Kind, Kind. I'm an attorney, a consumer attorney here in Las Vegas, and I echo everything that Ms. Romero said as things that we see routinely at our firm every day, and particularly when it comes to the abuses in connection with small dollar amount loans of medical debts, where we see the collection fees 50, 100% or more than that. And the only thing I would add on top of that is that countless times I see or I hear from potential clients where they reach out and the first notice that they received to inform them that they had these medical bills that were unpaid would be the summons and complaint. And at that point, they have a very short deadline to appear in court. So this is a big problem, and I really support this. Thank you very much.
Thank you so much for your testimony, Mr. Kind. Broadcasting, next caller, please.
Caller with the last three digits of 104. Please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good morning or afternoon, Chair, members of the committee. My name is Maria Teresa Lieberman Tarraga. That is MARIA-TERESA-LIEBERMANN-PARRAGA. And I'm here with that of Warm Progress. We're in full support of SB 248. And I'm here not only in that capacity, but as someone that, before having great insurance, I was one of these Nevadans that we were trying to help with this bill. And I personally had to crawl my way out of medical debt because of an emergency. And at the time, I had no idea how to navigate their problem, and neither did my mother. And it's the case with many, many Nevadans with no ability, knowledge to navigate a very difficult process that, even if you have knowledge or ability, is still difficult to go through. So, I'm sure COVID and its economic consequences have most likely made this worse. So this bill is coming at the perfect time, and we highly encourage you to support it. Thank you for your time.
Thank you for your testimony, Ms. Lieberman Paraga. Broadcasting, next caller, please.
Chair, there are no more callers for support at this time.
Thank you. We will now move into testimony in opposition. Seeing no one here in Carson City. Broadcasting, can we please check Zoom?
Chair, there is no one on the Zoom call to testify in opposition to AB 248.
Thank you, Mr. Lewis. Can we go to the telephone line for those wishing to testify in opposition?
Thank you, Chair. To testify in opposition of SB 248, please press star 9 now to take your place in the queue. Caller with the last three digits of 505. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good afternoon, Chair and members of the committee. My name is Peter Guzman, and I'm the president of the Latin Chamber of Commerce. As you know, the Latin Chamber is focused on jobs and economic development. This bill just recently came to our attention, and so we took a look at it because we have many business members in this chamber who are medical providers. Unfortunately, it appears this bill still needs some work. This bill would hurt those members who fall into the definitions of medical facilities and providers of emergency medical services. Again, we're very involved in this, including recently doing a job fair, hoping to create more EMT trainings and things alike. These medical businesses rely on collecting their accounts receivable. It's how they pay their employees. It's how they pay their rent. It's how they make a living and support our community. These medical providers take care of us when we need them. And if they can't collect on their valid debts, guess what happens? They lay off employees and eventually go out of business. We need more medical providers in our community, not less. This bill, as written, is a slap in the face to these medical businesses, legitimate medical businesses, and it's just bad policy. They shouldn't be punished for trying to charge and collect for their medical services. My fear is that this bill and bills like this will cause significant harm in many ways. It will drive up the cost of medical care. It will place a financial burden on medical providers and eventually drive medical professionals out of our community. Sometimes well-intended bills just don't work. This appears to be one of them. Thank you, Chair and committee members, for allowing me the time to speak
Mr.
today.
Guzman, we do have questions for you, so if you would please stay on the line. I'm going to go to Vice Chair Carlton.
Thank you very much, Madam Chair, and thank you, Mr. Guzman, for being here. I guess I'm just a little bit confused because the providers will still be able to sell their debt to the collection agencies. So I'm not sure if there's a misunderstanding as what the definition of medical providers is. So if you could clarify again what your concern is on this, because when I read the bill, it doesn't prohibit them from selling their debt to one of these companies. This just sets out a framework for collections. So if you could elaborate a little bit on the provider's issues.
Well, from what I've heard from the providers, this bill would just make it more difficult for them to rely on the collecting of their accounts receivable. So I think there is some confusion, and maybe that needs to be cleared up. But I can tell you this: I have not, out of all the members and all the years that this chamber has existed, we don't get complaints from people saying that they're getting mistreated by debt collectors or things that they legitimately feel that they owe, including medical, charges for medical services.
And Madam Chair, thank you very much. And Mr. Guzman, were you able to air your concerns on the Senate side, or did this come to you after the Senate work had been done?
Again, this bill just recently came to our attention.
Well, thank you. And, we always want to take everyone's viewpoints into consideration. I would hope that you would reach out to the sponsor and those working on the bill to make sure that you have a thorough understanding of the bill, because we want to make sure that all concerns get addressed. Thank you very much.
Thank you.
And I do appreciate that very much, because a lot of times good intentions have bad consequences.
Thank you, Mr. Guzman. And for the secretary, that was Mr. Peter Guzman from the Latin Chamber of Commerce answering questions. Okay, broadcasting, can we go to our next caller in opposition?
If you recently joined the call and would like to testify in opposition of Senate Bill 248, please press star 9 now to take your place in the queue. Caller with the last three digits of 009, please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Good morning. Hello, everyone. Hello, Madam Chair and members of the committee. This is Attorney Roberta Olinger Johnson. That is OHLINGER Johnson, JOHNSON. I'm an attorney and legislative chair of the Creditors' Rights Attorney Association of Nevada. Our members represent creditors before all courts of the state of Nevada, from Main Street to Wall Street, small claims to the Nevada Supreme Court and the Ninth Circuit, and even beyond. We would like to thank the sponsor for the amendment. We do think it addresses some issues that we had concerns with, but we don't think that it goes far enough. First of all, I would like to be very clear that we do represent, in regular course of our business, both original creditors as well as assignees. So that includes both original medical providers, hospitals, doctors, physicians, ambulance care, as well as medical debt that has been sold. As written and as amended, this bill would impact both directly. So we disagree highly, and I'm aware, and I'm available for questions, that this would simply, that saying that this allows hospitals to sell the debt addresses the central issue, which is that this covers all medical debt, including those that we are attempting to collect, that is still owned by the original creditor, in other words, the provider. I would also like to address, we do not quite understand the reach or scope of this amendment. There's a lot of discussion of attorney's fees here, and we are quite confused. Many attorneys accept a confession of judgment and dismiss the case unless there is a default. Well, we don't find that to be a bad thing. We find that to be actually quite helpful for a person who owes a debt to be able to enter into the agreement and then to be able to have that case dismissed unless there's a default. I also can't tell if this is I'm an attorney and not a collection agency, and I'm not licensed as a collection agency. I'm licensed as a law firm, and most of my members are, although not all, some are actually licensed as collection agencies. It depends on the individual agency and the way they're set up. This reaches me by attempting to legislate collections, and that That's quite confusing to me. For example, under Section 8.3, only an attorney can have an award of attorney's fees, and only judges can award attorney's fees. Collection agencies don't file suit, and I am not a collection agency. It is illegal under the rules of practice for an attorney to split fees with a non-attorney, such as a collection agency. I am
Thank you so much, Ms.
unable to
Olinger.
understand.
Ms. Olinger Johnson, thank you so much for your testimony. If you have any further testimony in writing, please feel free to email it to our committee manager or secretary, and we will distribute it to the members and put it on the record. At this time, we do have to move on to our next caller. Broadcasting, next caller in opposition, please.
Caller with the last three digits of 551, please solely state and spell your name for the record. You'll have 2 minutes and may begin.
Madam Chair, Vice Chair, and committee members, this is Scott Purcell, Scottpurcell. I'm the president of ACA International, the trade association of debt collectors. Can everyone hear me okay?
Yes, we can, Mr. Purcell.
Thank you so much. I would like to say there's a bit of baby in the bathwater going on here. I hear some of the examples in earlier testimony of agencies violating the law, including suing on out-of-statute debt. I can tell you ACA members subscribe to a code of ethics that prevents them from suing on out-of-statute debt, and we represent over 2,000 collection agencies nationwide. I also like to bring the committee's attention to a joint article between HFMA, Healthcare Financial Managers Association, and ACA, the best practices in medical debt collection. It was from September 2020. I can provide a copy if needed. That prevents extraordinary collection practices under a particular law I'll address in a minute, as well as credit reporting and legal activity and sales to buyers. So there's a ton of work that has gone on to help treat consumers professionally. As a society, with Obamacare, we, through Treasury Regulation 501R, that's the provider's societal contract to provide free or reduced care to the materially poor. Typically, those charity care, under 200%, it's free, 200 to 400% discount, and typically only over 400%. That's somebody making $105,000 a year for a family of four needs to pay their full share of the $6,500. And so we've got really good frameworks in play, and I feel like this is really well intended, but is going to hurt providers, which will reduce access and increase costs for the materially poor and the middle class, which is not, I don't think, what everybody's trying to accomplish.
Thank you for your testimony.
Any questions I can answer?
Thank you. Seeing no questions, we appreciate your testimony, Mr. Purcell. Broadcasting, next caller.
Caller with the last three digits of 802, please solely state and spell your name for the record. You'll have 2 minutes and may begin.
Yes, hi, this is Tim Myers. I am the president of the Nevada Collectors Association. Nevada Collectors Association is comprised of roughly 30 licensed collection agencies located within the state of Nevada. I've submitted testimony online in opposition. I won't read through it all. What I would like to do is ask a couple questions and put in a little bit of input here. Not all collection agencies are debt buyers. We are contingency-based companies, so basically we work on a contingency base and we only get paid if we collect. I hear a lot of testimony about debt buyers. What the one-size-fit-all approach here on this bill is that you're not thinking of the optometrist or the dentist or the chiropractor, the small practices who can't just go out and afford to hire a lawyer or whatnot. So they hire us and they count on us, and we only get paid if we collect their debt. Taking this away, sometimes we do have to sue. Not all debt is incurred by indigent and poor people. And by not allowing the smaller practices, the smaller physicians to proceed the debt or hire us to do the debt when they don't have time to do it is just it's taking it away. And this bill, this one-size-fits-all, is not a good draft of a bill. We're all about helping our consumers, our neighbors. We just need a little more help on this. And with the new amendment, a little more time would be appreciated, too, to see what we can do with that as well. With that, I'm done. I appreciate the opportunity. Thank you very much.
Thank you, Mr. Myers, and we appreciate you submitting your testimony in writing. Broadcasting, next caller, please.
Caller with the last three digits of 922. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
My name is Christian Lear, Christian, last name Lehr. I'm president of Healthcare Collections located in Phoenix, Arizona. I am also an ACA International Board member. I'm calling in opposition to this bill primarily because of the small to medium-sized providers that I service. Approximately 25% of my clients are, as referenced in the previous commenter, chiropractors, dentists, smaller health clinics. And their feeling is that this is asking them to bear the burden of people who do not want to pay their medical bills, that are able to pay their medical bills, because it will encourage them to not pay their medical bills. And in our experience, when bills such as this and other bills throughout the country have gone through, it has caused a decrease in medical providers who are willing to provide any services on credit. That means if you want to go to see your eye doctor, they're going to demand payment up front because they're aware that that person may not, and in some cases absolutely will not, pay the balance once the services have been rendered. It also concerns us because it seems to conflict quite a bit with the upcoming rules scheduled to go into effect at the end of November from the CFPB in terms of requirements for notices 60 days before taking any action. That conflicts directly with the requirements that collection agencies have to provide certain notices and certain information upon the initial communication. So that's a concern. We'd like to see that. I'd like to see that reworked. It's also a concern, again, that you're going to have medical providers not being able to contract with us. All of our work is on contingency fee. We're not a debt buyer either. And it may cause collection agencies to not service those providers, again, causing those providers to reduce access to medical services to those that can afford to pay up front because they're unwilling to take the risk of extending credit to them when they believe that that credit won't be repaid. Thank you for your time.
Thank you, Mr. Lear. Broadcasting, next caller, please.
Caller with the last three digits of 550. Please slowly state and spell your name for the record. You'll have 2 minutes and may begin. You are unmuted, caller, with the last three digits 550.
Good afternoon, Madam Chair and committee members. My name is Ann Silver, ANNSILVER. I serve as CEO of the Reno-Sparks Chamber of Commerce. We just became aware of this bill this morning and want to make sure that the bill does not harm our members who are medical providers, particularly smaller medical providers that have been mentioned in previous comments. We understand there is a proposed amendment which addresses some of the issues raised. And so we're happy to work with the sponsor and proponents to make sure both consumers and medical providers are protected. But as currently written, the Reno-Sparks Chamber of Record is opposed to Senate Bill 248. We appreciate your time and thank you.
Thank you, Ms. Silver. Broadcasting, next caller, please.
Chair, there are no more callers in opposition at this time.
Thank you. We will now move into testimony in the neutral position. Seeing no one here in Carson City, can we please check Zoom?
Chair, there is no one in the Zoom call to testify neutrally on AB 248.
Thank you, Mr. Lewis. Broadcasting, can we please check the telephone line?
Testify in neutral on Senate Bill 248. Please press star 9 now to take your place in the queue. Caller with the last three digits of 020, please slowly state and spell your name for the record. You'll have 2 minutes and we begin. Caller with the last three digits of 020, please press star 6 to unmute.
Madam Chair, members of the committee, for the record, my name is Jim Wadhams, Wadhams, appearing on behalf of the Nevada Hospital Association. I want to thank Senator Don Darrell Loop for connecting us with Bailey Bordelin and Sophia Romero. We were able to resolve some concerns we had in the drafting and the duplication of provisions that already apply to hospitals under NRS 449A. We appreciate their cooperation and are neutral on this bill. Thank you, Madam Chair.
Thank you so much, Mr. Wadhams. Broadcasting, next caller.
Chair, there are no more callers in neutral at this time.
Thank you. At this time, I would like to bring the bill sponsor forward for any closing remarks.
Thank you very much, Madam Chair. And I would thank all of you for listening to the bill today. I would also like to say that I have not heard from any of the opposition testifiers to this date, excepting on the phone line today. We have worked with medical providers, and they are fine with this. We've had conversations with all of them, and they are not impacted. And so I thank you very much for your time. And Ms. Romero has just a couple closing remarks as well. Thank you.
Thank you, Senator. Ms. Romero.
Sophia Romero for the record. In closing, I just want to clarify a couple points that it seems there has been some confusion on. This does not prevent a provider from collecting on a medical debt that is owed to them. This does not even prevent a provider from hiring an attorney to collect on a medical debt that was owed to them. They are the first party. They are not a third party collector. The medical debt is owed to them. Nothing in this bill applies to them. They are not even governed by this chapter. So this bill does not apply to medical providers. This bill comes into play when a debt collector has taken over the collection of this debt. This bill does not reduce the amount of the principal of the debt. This debt only limits the amount of collection fees that the collection agency can charge, and that the collection agency's attorney can, any amount of attorney's fees by the collection agency's attorney. This has nothing to do with a provider in any form. And so this will not, again, as you heard, the hospital association is neutral to this. This does not affect the provider's bottom line. It doesn't, this only applies once a debt collector is involved. And with that, I will close unless anybody has any questions for me.
Thank you, Ms. Romero. With that, we will close the hearing on Senate Bill 248. Thank you, Senator, and thank you, Ms. Romero. Thank you, Ms. Bordelin, for being here. Okay, members, our last bill on the agenda is Senate Bill 145. I believe we have Senator Spearman on Zoom with her co-presenter, Dr. Tiffany Tyler Garner. Thank you for joining us. At this time, I will open the hearing on SB 145, which revises provisions relating to financial institutions. Welcome to the committee, Senator. When you're ready, you can begin.
Thank you. And I apologize, I was going to sign a little bit earlier. I was in another meeting, but thank you anyway. Thank you, Chair Hodeggy and members of the committee. For the record, I am Pat Spearman, and I represent Senate District 1 in Clark County. And I'm pleased today to introduce to you Senate Bill 145, and I hope that it will receive positive consideration. Here's a little bit of background information. When the CRA or the Community Reinvestment Act, CRA, was enacted in 1977, it was intended to address certain discriminatory practices such as redlining. Since the 1930s, there has been an overwhelming evidence that banking institutions refuse to lend to some members of their communities, mostly people of color in urban areas who are seeking home or business loans. This has a direct impact on them personally and financially, because if someone who is non-BIPOC gets a loan for 3%, but someone in the BIPOC community gets that same loan, the same type of loan, for 4%, you can imagine the thousands of dollars, and in some cases, depending upon what they're getting a loan for, hundreds of thousands of dollars that extra that they would be spending. The CRA extends and clarifies a longstanding expectation that banks should and will serve in the convenience and needs of their local communities and not discriminate in their lending practices. However, our neighborhoods continue to be highly segregated based on race and income. Residential segregation has substantially negative effects, especially for disadvantaged families who are disproportionately subject to disadvantaged neighborhood environments in segregated metropolitan areas. Some of you may remember that last summer in August, we as the legislature signed onto a resolution that said racism is a public health crisis. And so part of that whole portfolio to make sure that we're dismantling it is Senate Bill 145. The CRA requires federal regulators to rate banks' performances and engagement in qualifying activities such as business, consumer, and mortgage lending, and low-cost services that would benefit low and moderate income areas. There are 4 federal bank supervisory agencies: the Office of the Comptroller of Currency, the Board of Governors of the Federal Reserve System, or the Office of Thrift Supervision, and the Federal Deposit Insurance Corporation. Most of us know that as the FDIC. And they periodically evaluate a financial institution's records and identify whether the institution is meeting the credit needs of its entire community. I will note that not every financial institution is evaluated by all 4 of these federal agencies. Banks have a primary federal supervisor based on their charging authority. Ultimately, the CRA is an important tool to hold its banks publicly accountable and expand financial opportunities and equity to Black, Indigenous, and people of color communities. Therefore, SB 145 will be a vehicle to educate Nevadans of the activities and investments of their local banks. I believe that making the bank CRA rating publicly available will provide social pressure that they must avoid discrimination in their lending programs and take steps to reduce historic patterns of discrimination in the past. What I'm really hoping to get out of this bill is to pull community organizations, not just individual consumers, but community organizations and banks, pull them together so that we know what resources we have as a community, and the bank can identify ways in which they can help our communities come back from COVID-19. There are some who estimate that we will not fully recover financially until the next decade. It is my hope that making this information public will allow those community organizations to understand what the Community Reinvestment Act is, what it can do, and make sure that we are doing everything that we can in our community to leverage this resource. And so that's the end of my testimony. What I'd like to do now is I'd like to turn it over to Dr. Tiffany Tyler Garner, and she can speak to how this will help community organizations in our neighborhood. That's okay with you, Madam Chair.
Yes, thank you, Senator. Dr. Tyler Gardner, thank you so much for being here. When you're ready.
Good afternoon, esteemed chair and committee members. Thank you for the opportunity to present in support of this important legislation. I'd like to talk to you about its benefits from 4 vantage points. 1, its ability to dramatically increase capacity building within the community, its ability to support asset mapping efforts, also its potential to help us further contextualize the investments happening in our state, and its ability to possibly foster practice among financial institutions. As someone who has lived and worked in the community, and particularly in nonprofit administration for a number of years now, I can tell you that we have a number of great financial institutions as partners who routinely engage in investments and support. And those supports include things like free financial literacy training, where they will actually dedicate members of their institutions to go out and freely share that in the community. So as I read this legislation and where it calls specifically for training nonprofits and other stakeholder groups on CRA, how it's worked, its intent, and the role that financial institutions play, I was ecstatic, particularly as I consider the efforts that go into raising resources as a nonprofit, having an awareness of understanding around how this policy would work, routine reporting, particularly on the investments they're making as a part of a larger ecosystem around addressing social issues, could be exponentially impactful from that standpoint. And then beyond that, as we hope to increase investments, including federal investments, or braid resources across systems or entities, the ability to leverage what we will know through this reporting for a match or to bring in additional resources could be incredibly impactful as a part of the need to address what are longstanding, pervasive historical issues in our community. Beyond that, having an understanding of the ways in which they are investing, the where, even if it's just by zip code or issue area, will help us to refine how we work across systems in coordination to mitigate these issues, particularly hopefully mitigating some duplication that might be happening or optimizing how we double down in particular areas because we know more about how folks are investing, where they're investing, and why as a part of the process. And then beyond that, the notation around there being an actual ranking or status or stature given to any particular entity can be helpful, particularly in raising the bar on practice. So the ability to be known as someone who routinely invests at a certain level, it's almost like setting the bar for your peers in some respects. And so from that perspective, I strongly encourage you to consider some of the benefits that may come out of it, whether it's helping us better understand as community members, like how CRA is an investment in our communities, how to partner with financial institutions, or helping us to understand where it's happening in our state as we seek to draw down more resources or bring more partners to the table around some critical social issues. And I would say particularly for children and families, I am hopeful about the impacts of this particular legislation. And so I'll pause there and see if there are any questions for me.
Thank you. Thank you, Dr. Tyler Garner and Senator Spearman. At this time, I will go to questions from the committee. Committee members? Okay. Assemblymember Hardy.
Thank you, Chair, and thank you, Senator, and for this bill and being here today. So I just had a couple of questions about the training sessions that you reference. So, and then it says a couple of times the number of training sessions required. Is there a set amount that the financial institutions would have to do each year? I was trying to read through and see if, is it 1, 2, 3? Do you have a set amount in the bill?
So through you, Madam Chair, to Assemblywoman Hardy, no, there's not a set amount. This is what I have asked of some of the community members in anticipation that indeed this legislation will pass, to work with banks in their area who are subject to the CRA and to set up the training sessions for them. And sessions, let me be clear about that. The training sessions aren't something that will take a day, 2 days, or whatever. What we're talking about is training sessions so that people understand, number one, what the CRA, what the Community Reinvestment Act is really all about. Number two, the areas that the bank is interested in or could become interested in. And number three, let's identify the issues within the communities, especially those that have been hardest hit in BIPOC. I mentioned earlier about lending rates. That's an opportunity for banks to understand and to help the community understand what the FICO scores mean with relationship to credit. If you're going to purchase a house, you're going to purchase a car or whatever, it's also an opportunity for banks to understand. We've got several organizations now who are addressing the homeless issue, and that's homeless issue not just in the South, but also in the North. And so it is an opportunity for people to come together and to learn about what CRA is. not just on the bank's perspective, but also within the community. So I didn't identify a quote set number because I really want them to work together.
Yes, follow up, please.
Thank you, Senator. And just because I don't know what that means, but what is BIPOC?
Black, Indigenous, and people of color. That takes it in people who are, some would call it emerging majorities. I would call it communities within our community that are usually marginalized and many times overlooked. Thank you for the question.
Thank you. And seeing no further questions at this time, I'm going to move us into testimony and support. Seeing no one here in Carson City Broadcasting, could you please check Zoom?
Chair, there's no one to testify in support in the Zoom call.
Thank you, Mr. Lewis. Broadcasting, can we please check the telephone line?
To testify in support of Senate Bill 145, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 261, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good afternoon. Thank you, Chair and members of the committee. My name is Jillian Block, Gillian Block, speaking in support of Senate Bill 145 today on behalf of the Nevada Coalition of Legal Service Providers. This bill promotes accountability by ensuring that the SID, the legislature, and the public are aware of the progress that each financial institution, subject to the reporting requirement, has made in expanding access to low-income Nevadans. Historic inequities have limited these Nevadans' access to lending and banking services. Legal service providers see the consequences of these inequities as their clients fall victim to predatory lenders who have filled the gaps left by the absence of mainstream financial institutions. Many institutions have made progress expanding access to less represented groups, and this bill will help give them the credit that they deserve. Other institutions will get some much-needed encouragement to think more inclusively and increase their efforts to reach out to historically excluded Nevadans. On behalf of our clients who deserve to have access to mainstream financial services, we support SB 145. Thank you.
Thank you for your testimony, Ms. Block. Broadcasting, next caller.
Chair, there are no more callers in support at this time.
Okay, seeing no one here in Carson City to testify in opposition, can we please check Zoom?
Chair, there is no one in Zoom to testify in opposition at this time.
Thank you, Mr. Stark. Broadcasting, can we please check the telephone line for those wishing to testify in opposition?
To testify in opposition on Senate Bill 145, please press star 9 now to take your place in the queue. Chair, there are no callers for opposition at this time.
Thank you. Now we will move into the neutral testimony. Seeing no one in Carson City, can we check Zoom to see if there's anyone wishing to testify in the neutral position to Senate Bill 145?
Chair, there is no one in the Zoom to testify in neutral position at this time.
Thank you, Mr. Stark. Broadcasting, can we please check the telephone line for those wishing to testify in the neutral position?
Testify in neutral on Senate Bill 145, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 306, please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Good afternoon, Chair and committee members. I'm Sandy O'Loughlin, SANDY-OLAUGHLIN, Commissioner of the Financial Institutions Division. I'm here today to provide neutral testimony for SB 145. This bill requires financial institutions subject to CRA to provide training to communities to assist Nevadans in understanding CRA requirements and the CRA ratings for those institutions to easily access on the division's website for Nevadans. The division looks forward to working with the Senator if any additional amendments should be necessary. Thank you for your time, and I am open to answer any questions the committee members may have.
Committee members, do we have any questions for Ms. O'Laughlin? Okay, thank you for your testimony. Broadcasting, next caller.
Chair, there are no more callers in neutral at this time.
Thank you. Senator Spearman, would you like to give any closing remarks?
Yes, ma'am. The bill is really straightforward. It's an opportunity, as I said before, to bring the banks, the financial that are subject to the the Community Reinvestment Act, as well as community organizations, nonprofit organizations together, so that each can understand this is a resource and this is what we're trying to do. Just a real quick testimony about how this can work. While I was stationed in Texas, we partnered with one of the banks there. There was an area of the city that was really blighted. There were homes that were abandoned. There were weedy lots, et cetera, et cetera. And you also had a number of people who were really wanting to become homeowners. And so what the bank did was the bank sponsored, excuse me, for 6 weeks, weekend classes that people could sign up for. And we held the classes at my church, and there was usually about 25 or 30 people that could sign up for the classes each week. Out of that partnership, we were able to get 20 more people in as homeowners because they understood, number one, what the credit qualifications were. They also understood going through the whole process of home buying. They also understood this is what it means to take care of the property. These are the things you have to do for maintenance, et cetera. And everybody that went through that program, the bank offered them a 0.5 point discount on their loan if they use them. So this is something that can work, and it's something that I hope we will be able to institute, because we're going to need a lot of help coming out of the COVID environment. So with that, thank you, Madam Chair and committee members, for listening, and thank you, Dr. Tiffany Tyler-Garner, for coming, and I want to thank FID for showing up, and I worked diligently with them to try to help us get through this bill and several others. So with that, that's all I have, unless there is.
Thank you, Senator. We appreciate you being here and appreciate your co-presenters. At this time, I will close the hearing on Senate Bill 145. Members, we have one other item on our agenda left, and since there is a lag of about a minute for those watching on YouTube and on Nellis, I will just quickly read through our public comment housekeeping to give them time to call in. I would like to remind those listening that the period for public comment is an opportunity to discuss general matters that fall within the purview of this committee. Please address your remarks to issues that fall within the jurisdiction of Commerce and Labor. If you direct your remarks to issues over which this committee has no oversight, I will ask you to redirect or terminate them. The public has already been given time to support or oppose specific legislation. We open and close hearings on all bills so that we establish a record of the public testimony on a bill. We do limit public comment to 2 minutes. I would also like to remind those listening that you may always submit written remarks for inclusion in the meeting record. Be respectful of committee members and other witnesses. Do not comment on testimony provided by other speakers, and do not make personal attacks. With that, seeing no one here in Carson City to give public comment, broadcasting, can we please check the telephone line?
To take your place in public comment, please press *9 now to join the queue. Chair, the public line is open and working, but there are no callers at this time.
Thank you so much. Thank you, committee members, for Friday's version of Commerce and Labor. I appreciate all the questions that you all had. I was able to get all of my questions answered through you. With that, our next meeting will be on Monday at 1:30, and we are adjourned. Enjoy your weekend.